Good evening, everybody. I would like to welcome you to our lecture today, which will be from a legal perspective, not only from a legal perspective. Our guest is Marie Beyrich. A warm welcome from our side. She has studied law in Regensburg, and then she completed also the second phase of the legal education with a second state exam, and then she worked on her thesis, which has been published, I think, 2 years ago. This book will be also the focus of her presentation, her lecture today. And now she is akademische Rätin auf Zeit. I do not dare to translate this, a postdoc position at the University of Regensburg, and she's working on a habilitation, also a very German concept, in the field of protection of democracy, also with a comparative aspect. She has also been a visiting scholar for half a year at the University of California at the first phase when she started her dissertation, and she has received several grants by the Studienstiftung des Deutschen Volkes and also others. And she does what is interesting for us, not only traditional legal research, but is combining this with a look at administrative practice and analyzes how law is implemented. There's a saying that usual legal scholars only analyze the law in the books, and she is analyzing not only the law in the books, but also the law in practice, how it is implemented or how it is not implemented. So a warm welcome, the floor is yours.
Yeah, thank you. Very happy to be here, and I've never presented anything in front of such a diverse audience, so I'm very curious to our discussion afterwards. But first, my presentation, it's my PhD, and yes, it was published last year, so I also have a QR code, so if you're interested, through the university VP, and it should be accessible. Yeah, so the topic I'm going quickly back is Right Only on Paper, Family Reunification in German Administrative Practice. So what I've done is finding out how the law in regards to family reunification is implemented in practice. So how does it work? Does it work? And if so, yes, how? What are the problems? How is it implemented? So I've tried to analyze the administrative practice. Going forward, starting with my research finding, this is what I found out. So the law in the book is very clear when it comes to family reunification. So close relatives have a right to family reunification. And this is more or less clear. Yeah. So of course they need to prove certain requirements, but in the end, the law, there's nothing uncertain or unclear. In practice, however, the picture is completely different, because oftentimes the affected ones cannot achieve their right to family reunification due to hundreds of practical problems and bureaucratic hurdles they need to overcome. And in consequence, this right is implemented most of the time only with great difficulties and with high costs, and in some cases not at all, because affected ones cannot overcome the hurdles, or they give up, or family ties dissolve, etc., etc. But let's start with my starting point. So I came up with this topic because I was working at a refugee law clinic which we established at our university, and so I also had cases with family reunification, and I think I started 2015 to work there, and it was one of my first cases, family reunification, and I had it till the end of my studies, starting my PhD with this topic, and we weren't finished yet. So I knew already, okay, family reunification, that's a topic that's quite difficult in practice. And so I went to my supervisor and I said, okay, I want to do, if I do a PhD, I want to do something, it's relevant for practice and not only in theory. And so he said, okay, let's get into family reunification. And then I tried to figure out how to get insight in the administrative practice, and I found out that there's no research ever done when it comes to family reunification. So there was nothing for me there. So I knew, okay, I need to somehow gather all the information about administrative practice by myself. And so my second thought was, okay, how do I do that? How, interviews, that's very uncommon for legal researchers. And then who do I interview? How to manage all that? And yeah, the starting point was that I knew we have lots of different actors involved, and they all experience the administrative practice, but only partly. And only the affected ones, of course, experience the practice from start till the end. And so I tried to bring them all together to get interviews with every actor involved, and having also the stories told by the affected ones, because I knew my book, first of all, will be read probably only by legal researchers, so I tried to make it a bit more real for them and not so abstract. Methodology. That was a difficult one for me as a legal researcher, because I knew, okay, I cannot just look into books and read, but need to do interviews. And we had a lack of any kind of research in regards to administrative practice, so it was clear I need to do it exploratory, and I need to do a qualitative approach doing interviews. And that's a quote from my supervisor, who said in his opinion after he read my dissertation, and of course was with me there during the years, and said it was like a scavenger hunt, because I went from clue to clue, from one dead end to another. Lawyer who said, look at this website, look at this leaflet, let's talk to this person because he or she knows that family reunification to Afghan people looks that way. And so I did a scavenger hunt through 3 years and tried to gather all the information about administrative practice when it comes to the implementation of the right to family reunification. And so I did the interviews with all the actors involved. I tried to get also authorities involved, but that was a clear dead end. I wanted, of course, people who work in embassies or the Federal Foreign Agency, but there was no coming through, because I never got an answer throughout my 4 years of dissertation, which is why this perspective is not present. In regards to all the other actors, I got at least one interview, which I think is a good thing. Besides that, I also gathered all the other information that is available in regards to the administrative practice, for example, leaflets, for example, parliamentary inquiries, and after quite some time, I had my basis to start writing my thesis, and my main challenge then was demonstrating a quantitative dimension, because I chose a qualitative approach, and of course I wanted to somehow avoid that people tell me, hey, these problems, these are just isolated cases, and this is not a general problem. We don't have a systemic issue here. It's just singular cases that you are telling us. And so that was my main problem, how to show a quantitative dimension, and I did that through showing some numbers, because for at least some parts of the process there are numbers available. Plus, I tried to order the problems that the actors involved told me, tried to order them into categories, and then I could, if affected ones are in this category, it's very likely that they will face these problems that are in this category. And so through that, I could show a quantitative dimension, and we will get to that after my theory first thing here. A bit more general first. So why is it relevant for us to somehow show how administrative practice works? And that might be maybe very clear for you, but at least for legal researchers that's not very clear, because oftentimes now during the academic career path, I often get the question, why the hell did you do that? Because that's not a smart way to start your career doing social legal research. So it's not very clear for legal researchers to do that. So why is it so important? Of course, because that's the main function for law, that it works in practice. So if law doesn't work in practice, we did something wrong, or we need to change something. That's the main function. So if there is a gap between law in the books and law in practice, we have a problem. And I think it's like the people who work in family reunification cases know that there is a huge problem here, because we have this gap here. And through this implementation gap, de facto legal rights are denied, because they cannot be implemented, at least not quickly enough and not with like an appropriate amount of money you need to come up with. So that's like generally why it's important to take care of that. Challenges are that we have a very fragmented field, because we have many actors who are involved, many different institutions, many different agencies, and so it's very difficult. So there's no institution that documents the whole process from the beginning till the end. So it's very difficult to get all the information that's relevant about administrative practice. And then there's the many processes are not really accessible, because you need to do a research like that to get access, and even then you don't get access to every kind of information, because many things are just informal and not like transparent and accessible. And for me, it was also difficult to only rely on individuals telling me their experience, because I was always like aware that people might come and tell me that's just, a story, just anecdotal stuff a person told you. And so that's the problem of how to show that we have a systematic issue here. So my work is mainly based on interviews, which is maybe more common for you, but very uncommon for legal researchers. Okay, so that's everything to the theory or the method. Back to my research findings. So, first of all, the law in the books. German law grants a right to family, to close relatives, at least of refugees. With people who have subsidiary protection, it's a bit more difficult, but even there we have a right that grants family reunification. So very clear from that side. In practice, we have these practical problems. Almost in every step of the procedure, of the process, there is a problem that needs to be overcome in the end. And this is not limited only to isolated cases. No, I can show that we have as a systemic problem here. So in the end, I found out that there are lots of people who achieve their right in the very end, but it is very rare that these people get this done without a disproportionate delay or disproportionate costs. And conversely, almost all of these people need to overcome these problems, and through the problems, the delays and the costs, to achieve their right. And it is very likely, because of that some people will fail, will not even try because they know how problematic this whole process is, or will fail throughout the process because they cannot do it anymore, or family ties dissolve, or they might even die, and so on and so on. What are the obstacles that they face? So I categorized them, as I told you, in 3 different categories, and we have obstacles that affect most of the applicants or almost all applicants. Then we have obstacles that are connected to the nationality of the affected ones, and then we have obstacles that are connected to the scenario of family reunification. So we need to differ between family reunification to people with subsidiary protection or to people who have a refugee protection status. The first category, affecting all or most applicants, the most common problem is the amount of money you need to have to achieve your right to family reunification, because every step of the procedure costs money, and the more problems you face, the more money you need to have, because every overcoming of the problem also costs money. Even if it's just the appointment for the application, for submitting the application for family reunification takes time, 2 years. This costs money because you need to somehow finance your life in these 2 years in a different city oftentimes, because people from Eritrea, for example, cannot live at home and apply electronically. No, they need to cross borders, go to another country and apply there. So they need to finance their life there. Or better said, the person who's already in Germany needs to somehow come up with the money to finance the life there. And in the interviews, the amount of money was assessed round about 10,000 to 15,000 euros overall throughout the whole process. And this means people who cannot afford this cannot achieve their right to family reunification. And of course it differs. The more problems you face, the more money you need to have. Second, obstacles to specific to certain nationalities, and the most familiar one is Eritrean affected ones, because this family reunification process is so difficult. So this is the most common example. So for example, I already said that Eritrean nationals, they have the first problem already with the closed or at least not in regards to visa for family reunification. The German embassy doesn't work in Eritrea. So they know that they need to leave the country and go somewhere else in the neighboring countries to apply for family reunification. So that's the very starting point of the procedure. And then in Eritrea, it's the case that you cannot just leave the country, you need an exit visa. So you need to somehow get this exit visa. And this is not so easy because you need to have a reason for this exit visa. And a reason would be, for example, to get some medical stuff going on somewhere else, and you can't just get it somewhere else, so you need this exit visa. But achieving your right to family reunification to your relative who fled the country to another country, to Germany, that's not a reason why you get an exit visa. So most of the times people need to leave the country illegally, and you have to somehow manage that to leave that country and be alive afterwards and be somewhere in the neighboring countries to only apply for family reunification. And this example, I think, makes it very clear that all of Eritrean nationals who live still in Eritrea need to overcome this exact problem. And if they don't overcome it, they cannot apply for family reunification because it's not possible electronically, and you need to do that in a German embassy. So you need to leave the country. Third category is obstacles specific to certain family reunification scenarios, and one very drastic example is the family reunification to people who have only subsidiary protection, because here in practice the process goes like that. The embassies, so in the law it says per month 1,000 relatives can get a visa for family reunification. So only 1,000 people can come to Germany through a family reunification visa. And then there are some factors why you are prioritized in this process through law. For example, if you are a minor, you need to be prioritized in the ranking, like who are the 1,000 people who can come to Germany. That's the law. In practice, there has never been such a prioritization decision, because the embassies handle the process like that they give out a number per week, how many people can apply, can submit their application for family reunification, with the consequence that they never need to prioritize, because there are never more than 1,000 people in the pipeline. Which is why the law, how it exists in the books, is not applied the way it should be, because we would have to have more appointments for submitting the application for family reunification, and it doesn't take place. So I think that's a very crazy example for this kind of obstacles that are taking place in practice. And so for people who want to achieve their right to family reunification to someone who has subsidiary protection, they usually wait a very long time to get an appointment. But then afterwards, it's rather quickly the process, because, if you fulfill the requirements, usually there's not really any problems you need to overcome then, but you have this waiting time before that can be very long. Yeah, so these are the categories I try to order the problems in. And then I also used some data and statistics to somehow support my findings. And first of all, I need to mention that many processes are not recorded or somehow is somewhere in statistics captured, because we don't do that. So we have just for parts of the process, we have some numbers, and so we it gives us some hints and support for the findings I got through the interviews, but only through numbers. We cannot prove anything really, because there is not enough numbers. I brought two different numbers, and I know it's German. I try to translate it. So here we have numbers in regards to Eritrean people, and the second line are the numbers of how many people got a protection status. So either subsidiary protection, refugee protection, or asylum protection. And the third line is how many people got a visa for family reunification. And first line is the years. And so we can see that in 2016, so right after 2015, so many people got a protection status, Eritrean nationals got a protection status, but very little people only got visa for family reunification, which would be in the first year understandable, because of course we have not simultaneously procedures going on, but first protection status, afterwards family reunification, right? So the numbers must rise afterwards only. And we can see that the number is rising in 2018 and 2019, 20, then the numbers are already going down again for family reunification visa. And also we would maybe expect that the numbers are way higher for family reunification, because if you think that maybe half of the people who get a protection status also want at least one family member to come, then the numbers would have to be much higher than they are. And they are not. So this supports that for Eritrean nationals it's very difficult to actually achieve the right to family reunification in the end. Yeah. Next, I have numbers for the waiting times, which is a very common problem in family reunification procedures, because it just takes so long in certain embassies to get an appointment to apply for family reunification. And here I have the most common embassies where also Eritrean nationals usually apply for family reunification, and it shows that already in 2019 it was in Nairobi, for example, at least 18 months, and in Addis Abeba it was 7 to 8 months. Khartoum, the embassy was closed for that in that time, so no timeline for that. And we might still explain that we had refugee crisis in 2015 and 16, and so even in 2019 still the embassies were so crowded and overworked that they couldn't process all the visa stuff. But also almost a year later the numbers still went up for Addis Abeba, for example, and that was right before COVID, so COVID wasn't an explanation there for February 2020, and still the numbers, 14, 13, 10 months waiting only for the appointment where you submit your application. A year, more than a year, that's crazy, okay? That's not normal. That's not how it should work. And now in last year, May 2024, right before my dissertation was published, it was almost 2 years in Nairobi, and more than significantly, so the website said significantly more than 12 months. And lawyers told me that it's also 2 years there. So yeah, and of course we all know that people try to explain that still with COVID, because embassies were closed and we're still trying to manage COVID consequences. But yeah, even if that's the case, that cannot be reality. Okay, waiting more than 2 years for applying for your right is just not the time we want to have. And we have other countries, for example, Sweden, I think, is the country who has this rule, 3 months, okay? And that's in the law. So here we have like a tool that we could establish to somehow make this quicker. But yeah, we probably don't want to. So yeah, that's the case, 2 years. So to come to a conclusion, I found out that lots of mainly lawyers told me that they observed a shift after 2015. So before that, it might have taken also longer to achieve your right, not as long as it takes now, but also it was a long process. You had to overcome also different practical problems, but usually you could somehow agree at some point with the embassy to get your visa for family reunification. You usually didn't have to go to the courts to achieve your right. And embassies, were more accessible. You could work with them somehow. They were accessible. And after 2015, they closed. Yeah, they were not accessible anymore. They got way more restrictive in their practice. Wherever they had a discretionary thing by law, they handled it more restrictive than before. So there was this clear shift after 2015 and got way more restrictive. And yeah, so legal rights exist, but enforcing them in practice are only possible with great difficulty. You need to expect at least time delay and costs, and certain other problems on the way. And so you need to have this resilience, firstly, as affected ones, and also you need to have help, because I don't know how people without help and without knowledge about the institutions and how processes work could ever overcome all these problems they face during the process. And lastly, a question that I also asked myself was responsibility. Is there someone we can point a finger and say, you are responsible for all that catastrophe happening here? And that's very difficult, because this process has these different actors and these different institutions, and the process already starts before getting in touch with one of the German institutions. Already starts with fleeing the country, and then the family relatives needing to leave the country because embassies are closed. There we don't have a contact to a German institutions already. It's before that, and there are already different difficulties happening. And then, only then, German institutions are involved, and then we have the embassy, and then we have the Ausländerbehörde, and then we have IOM, and then we have a court, and then we have another court maybe, and so on and so on. So we have a system where it's very easy to say, well, that's not my responsibility. I am only this small, the small institution here within this whole process, so you cannot blame me, right? So that's why, it's very difficult to just, point the finger to an institution. That does not mean that there aren't any solutions that are possible also through law, for example. Yeah, for example, the 3 months rule, or trying to implement an electronic application. Why not, right? But with current developments, again, we're rather facing the will to make it also in the law more difficult to achieve a right to family reunification wherever it's possible than to make it any easier. Yeah, so that's everything for me. Thank you.